Thank you all for joining us for this afternoon's presentation. I'm really delighted that we have two wonderful guests from Vermont Law School joining us, and I'm going to introduce them, and I'm hopefully not going to mess up their names. So Nicole Killoran, that's the Irish way. Nicole is a mother of twins and a singleton, and she teaches at Vermont Law School in two departments, the JD Externship Program and the Vermont Law School Entrepreneurship Legal Lab and VLCEL. Is that how you say it, VLCEL? Okay.
That's the acronym for it, VCEL.
Okay, great. She has a background in food, specialty French pastries, yum, and breads, as well as experience in a couple of different areas of law, including land use and environmental law, bankruptcy, mediation, and litigation. One of her interests is early childhood development and how kids' brains grow and thrive in different learning environments. I would imagine that's a good thing to have with three of those.
Yes, it is, especially with twins.
Yeah, absolutely. And then we have Adrina Shepion. Close, huh? She's an accelerated law student at Vermont Law School, where she's also a student clinician with the VLS Entrepreneurship and Legal Lab and on the intensive trial practice team. Before law school, she worked as a paralegal in employment, criminal defense, and bankruptcy law. All right, so here's how this is going to go. They have a great presentation that'll be maybe 40-45 minutes or so, and then leaving it for Q&A. If you do have a question in between, though, Nicole and Adrina, do you want them to put it in the chat and then you'll answer it right away, or do you want to wait until you're finished speaking? Probably after you're finished speaking.
I think we can, if there's questions that come up in the chat while Adrina is presenting, I'll speak up, and then while I'm presenting, she will speak up. So we can just answer them as we go along. Sounds fine to me.
Okay, so then, so we'll be wrapping up with this part at around 5. And then just to let you know, those of you that are on, if you have any questions that regarding our assignment from last Thursday, or your assignment or the work, you have time to do a little bit of work with Ask Tammy Jo or Lisa questions. So let's take it away. How's that? And thank you again for joining us, all of you, and for our two speakers.
Go ahead, Adrina.
Hello, everyone. Thank you for joining us. What me and Nicole Killoran are going to be doing today is talking about the logistics of hiring an attorney, getting rid of any fears or misconceptions that certain businesses have that basically drive them away from hiring an attorney, and also explaining why you in the childcare field might need one or consider one for your practice to be able to comfortably move through your business, do what you love, and know that you're protected on the outside of things rather than getting hit with the curveball and being in a position where you might need an attorney and won't necessarily be able to afford one. And playing defense is always a lot more expensive than just resolving a few issues and understanding some potential things in the beginning of things. So I would like to start with when are some times that you should be hiring a lawyer. So first things first, lawyers are trusted advisors. Trusted advisors can help you get a better understanding of your business and run your business a little bit more effectively so that you can do what you love and they can handle all the business side and financial side of things effectively and also cost effectively, where you will be limiting your liability and any issues that could arise in the future. Trusted advisors are people like accountants, consultants, coaches. If you have an advisory board member, someone you reach out to, these people don't have to be people that come with a big price tag. It could be anyone, just someone that could give you a clear understanding of certain circumstances that you can face. And And each one of these advisors has a different role, and it's important for each one to play their role. The attorney, for example, plays an important role in the legal aspects of your business. These could be employment, such as employee handbooks, waivers, business formation could help you understand what form of entity to file your business under so that you can limit your liability moving forward. So per se, if you were a sole proprietor and followed and listed under a sole proprietor, it might be better to become an LLC because that becomes a liability shield. So if anything ever happens, your home or assets aren't part of the collection of any lawsuit. If you lose a lawsuit, for example, your home and your assets aren't in the list of things that they can essentially take and liquidate. Transactions, land use could be very important, especially if you are running your child care service out of your home. Transition planning, government affairs, following regulations, compliance with permitting. Again, especially if you are a child care provider for more than 2 kids in Vermont, and making sure that you're on board and on top of the permits and you're not falling behind on any of them. IP in certain scenarios and liability and risk assessment of the way you run your business. If you have more kids, that might be a little bit more of a thing for you to consider. So out of all of these, the issue becomes, why should I hire a lawyer? It's important to hire them at the outset of things in the beginning to just give you preventative feedback rather than afterwards as a defense. The cost is going to be massively different. And if you think you can't afford a lawyer, it's going to be much more expensive in the back end of things. So lawyers become a very helpful part of your team. They have a duty to provide you with the best possible advice. And there's no question of loyalty and there's no question of intent of whether they're on your side. In fact, your lawyer can do all these things for you, and the rules of professional conduct actually require them to act ethically and only consider your best interest in your representation. And if an attorney fails to do that, they could face disciplinary action. So they can face issues with their licensing. So they're held to a very high, tight standard. And you could ensure that a competent attorney will be able to give you some legal expertise, education, or be an advisor and an advocate for you. And just to be able to bounce off issues, bounce off suggestions, work with you to progress your business or to just keep it safe and make sure you can see around the corner. Next slide, please. I want to show you this in, let's say, an employment attorney setting, because it's one that, all businesses have this in common. If you have an employee, this is something that you should consider. Let's say for employee handbooks, it could be almost like a bylaw book of introducing your staff to your culture, communicate your expectations, educate employees on what they can expect from your management and your leadership side of the things. And it really ensures that key company policies are very consistently and clearly communicated and listed, along with benefits, your compliance with state and federal laws, and it helps defend against any employment claims. So if you have a company handbook that says, this is what we need, this is what
recording in progress.
This is what we expect. I'm getting some feedback. Okay, sorry about that.
I'm muted. We're good.
And it could be a bylaw of, this is what I want, this is what you need to give, these are some things you can expect, this is the way we go through things, so that at the outset of things, if there's any, oh, but I didn't know this, or the company doesn't do this, you have the bylaws, essentially, just your company handbook to pass and say, but you've signed this, you've seen it. So it gives them a very clear understanding of what you and your company stand for and clears up any issues in the event they decide to pursue any kind of action, let's say, against you. So these can be relayed. However, there's a slight thing with employee handbooks that if they're not done professionally, you can accidentally include language that will create like what's called an implied contract, where because it wasn't formulated and written properly, you can open yourself up to liability. And it could be a lot more expensive and difficult to dig yourself out of that. So it's important that they're drafted correctly. Um, some examples of implied contracts are progressive discipline policies. These can be that if you do this, this, and this, specifically, if you list out things that a company can't do or an employee can't do, and things that they can be penalized for, or have any other disciplinary repercussion, it could be interpreted by a disgruntled employee at the outlet, at the end set of things, that these are the only reasons why I could have been terminated, and I was terminated for another reason. Vermont is an at-will state, which means that an employee can be terminated. As an employer, you can terminate any employee for any reason without cause, just so as long as it's not illegal. But when you put these little languages that make this chain of a little implied contract that's anything outside of that, you can almost make it read as though they weren't an at-will employee and they can be only terminated for certain reasons. Same goes for adding a probationary period, limiting the language. Some employees have had, unfortunately, these languages can create a different form of interpretation. That's not what it was supposed to stand for. If you call an employee probationary period, and then once that period's done, a permanent employee, it could be interpreted to read that because they're a permanent employee now, they don't fall under an at-will structure, and now they really can't be terminated. So if you terminate them for any reason, you could open yourself up to, at the minimum, a lawsuit. It's just these things where your intention for forming this language can be turned entirely around, and it's just not worth hiring expensive help to help dig yourself out of these things that could have been prevented. The last one is assurances of job security. These are ones that, we come from small businesses, and these can almost be the scariest, because if you give a hint of job security, saying that if you do a great work, you can stay as part of the family, or if you do good work, you'll stay as part of the family. That could have the definition of a job security, meaning that if they think they're doing good work and they get terminated for whatever reason, even if it's just a completely unrelated, that could be their argument for, well, I had job assurity because I was a good employee. So it could limit your protections, and these are all avoidable. Employment lawyers, employment attorneys can help you resolve these issues because they have done work on this. This is some attorneys' specialization. So ways to avoid these could be avoiding implied contracts. And this means to include an acknowledgement form in the employee handbook at the end, just a written acknowledgement that I'm signing this handbook because I have read it and I acknowledge its contents. An at-will disclaimer in clause in the handbook could say that I am an at-will employee. I acknowledge that. I acknowledge the terms of the handbook, and however way I may interpret the handbook doesn't stray from the fact that I am an at-will employee. And next is avoiding any promises of job security. This language can be extremely tricky. If it can be interpreted differently, it can raise issues. You want to make sure it's as straightforward, but don't try to cloud the document with too much information, because if you start specifically listing things, that could just keep digging a little hole that you don't want to be in. So going back to the topic of why should I hire a lawyer for an employment attorney, for example, they're a helpful part of your team. They know what you can't do, and they have a duty to provide you with the best possible advice. And there's no question of loyalty. So if you hire an attorney in the outset of things to even draft up a company handbook or to look through disciplinary policies for you, they will be ethically barred from being the attorney of any employee from your company that sues you. There is a mm, they're ethically barred from representing anyone who goes directly against your interest. They can become
Conflict of interest.
That's slipped me. It would be a conflict of interest to represent anyone from your company. So you almost have a monopoly on your attorney and the information you have given them. So it's fully protected. They can give you legal expertise on the changing Vermont laws. In this example, just employment law in Vermont, they can help you figure out language that works for your goals in certain scenarios. They can educate you about the law. They can advise you on any issues that you foresee in your business, or you can ask them what issues that they foresee in your business so that you can be ahead of the ball and not catch it when it gets a little too expensive at the back end of things. So they can advise you on different business issues, and it will always be in your best interest. And lastly, especially for employment, they can advocate for you. If anything happens, the back end of things, they can be your advocate in a court setting and help you through these issues that they've been with you from the beginning of the ride. So it's not going to be a brand new situation to a brand new attorney that has to get caught up and now represent you. This is a person that you have closely worked with, that knows your unique goals, your unique situations, and how to uniquely help you move forward. Some places that you can, there's access to these attorneys, especially when you don't have the financial means. Attorneys can be expensive, but it doesn't mean that the only way to hire an attorney is to spend boatloads of money. There's a South Royalton Legal Clinic. They do low and pro bono work, which means that if you qualify, you can either get legal help for no cost or low cost. There's the Vermont Legal Aid. Works the same way as South Royalton Legal Clinic. It's low and pro bono, and both of these institutions you can call, put in your claim, and if they can help you, they will give you a call and get the process started. And their websites can give a lot of help too. The VBA Modest Means Project is a really great tool, because if you don't qualify for legal aid, the VBA Modest Means Project actually gives you a lower cost than a traditional attorney's fee. So you can sit right in the middle. If you can't get it at the lowest cost, if you don't qualify for it and you still can't afford a regular attorney, they will give you a lower cost for legal help. And then there's the Vermont Bar Association lawyer referral service. It's an incredible tool. It is essentially an index of all the attorneys in Vermont. You can either go through it, categorize based off fields of, let's say I'm looking for an employment attorney. You can click employment lawyer and literally go down a list and start calling and try to get some information. And even better, you can reach out to the Vermont Bar Association referral service via phone. Tell them what you're looking for, tell them your case, and they'll actually connect you with attorneys. So they will have attorneys call you to help you. So they'll do the looking for you. These are the reasons why these attorneys are listed on the website. They're looking for people that they can help, and it becomes a really great tool to connecting you as a professional with a legal professional. And the consultations with attorneys can there could be a fee with consultations. And the great thing with this referral service is that if you get a consultation through them, the half-hour consultation, at least the half-hour consultation with the attorney will be no more than $25. So if an attorney is charging $100 for a consultation, if you reach them through the referral service, first half hour is only $25. So it's almost a coupon code, which is awesome. After you find an attorney, I feel like there's an issue of, I got an attorney, now what?
I just want to add one, actually, while I was thinking, Adrina, I don't know why we didn't add this in the first place, but because we help small businesses through the Vermont Law School Entrepreneurship Legal Lab, you can also, if you'd like, you can either go through the Small Business Development Center, the SBDC, or if you'd like, you can come directly to us potentially for a legal educational consult through BCEL. We are able to provide free legal education on issues related to your business. And for certain folks, we are able to provide then 5 to 10 hours of free paid legal services. So that's an option as well. And we have our website listed in the last slide. I don't know why we didn't put that in there.
My brain didn't even register that.
Right?
Awesome. Yeah, absolutely. We're what our job is to help businesses that otherwise couldn't afford it. So please reach out. That's literally why we're here. Some qualities to look for in an attorney. I feel like there's this wall between people hiring an attorney and what to expect back. So rapport is one of the most important ones. Make sure that you have a good communication with them. They are the people that you are going to spend time with, talking about personal aspects of your business. Your business is your livelihood. You want to make sure the person you're hiring has the capacity to comprehend that on a personal level and be able to help you. Experience is probably, should be a given for the attorney, but make sure that they are experienced in what you're asking them to do. Everything that you take to an attorney is unique to you. It could be what the attorney does every other day, but you want to make sure of that. You want to make sure that if you're telling them your issue or your concern, they have experience in that field so that they can give you guidance and suggestions and background and effectively help you. At the end of the day, you are paying for it, so you want to make sure you are getting the most comprehensive and competent help that you can in return. Availability is important because you want to make sure your attorney is going to respond to you. Attorneys have a need to respond to clients according to the rules of ethics in a reasonable time, but attorneys do get busy, and sometimes this just isn't followed. That's the reality of it. It could take some time. So make sure that when you reach out to an attorney, they're getting back to you effectively and timely. If the time gap isn't working for you, you absolutely still have the opportunity to look around, shop around, call other attorneys, see what works for you. If the best way to reach them is via phone, see how long it takes them to get back to you for the consultation. If it's via email, see how long their response is. If any issues with you come up, you want to make sure that if you call your attorney, they're going to give you a call back in a timely manner and ease any anxieties, any issues, any stresses. It's their job. Next is referral. If they can't help you, whether it's because they don't have the experience or they don't feel comfortable or they just don't have the client capacity to take on more clients, see if they can refer you to someone else they recommend. Attorneys often work together. So if they can't help you, they might be able to refer you to someone that can. And last one, that's personally most important, is that you're comfortable talking with this attorney. As much as they're interviewing you, you're interviewing them. You are going to be the ones paying them. You're going to be speaking to them. You're going to be working with them on something very important. It's your business. You want to make sure that you're comfortable and nothing is weird with this attorney. If you have any questions, that they can answer in English and not in legal words. Because if they can't explain to you responses to your issues that you're actually having, if you don't understand it, it seems backwards, and it can mean that they're not the best fit for you. So make sure that you're comfortable with the attorney, and the feedback you're getting is helpful. And the discomfort can reflect in a lot of ways. And one, understanding what you need and what issues the attorney's actually resolving. Two, what the attorney's actually doing, because if they're just explaining things to you in words you don't understand, you're going to get a bill at the end of this and you're not going to quite understand what's on it, and you're not going to know where it came out of. And you'd rather not find these things out when there's a bill in front of you that now you're considering disputing, that you have to pay, or, you're in a position where you can't afford to. The process of interviewing a lawyer. Again, as much as the lawyer is interviewing you, you're interviewing them. They have to be a good fit. So in your initial consultation, ask them if it's free. If it's not free, you can negotiate. Don't be scared to negotiate. It's not always a fixed price. So ask them if it can be, it can be a free consultation. Ask them if you can have it at a discounted rate. In this meeting, include key players. This is anyone with managerial position, anyone that has a day-to-day decision-making process in your business. These are the people that know how your business runs and can effectively relay information to this attorney, or you might be able to get this information out in the free consultation and not have to communicate it to your lawyer when you're actually getting billed in the rest of the relationship. So it's important to have the people there who understand your business. Next is do a conflicts check. Your attorney will do this. It just means that your attorney's not representing, let's say, another business that conflicts with yours. If it's too close to comfort, they won't be able to do it. If, let's say, they're also representing an employee of yours and you're reaching out to them more of in defense mode to deal with issues, they'll do that conflict check and they'll find that they can't represent you, and they'll maintain their employee relationship with your employee. So that's another reason to get ahead of it, so that you can gain a rapport with an attorney. Another question to consider is, how deep is the bench? What this means is, you want to know how many attorneys are in line if something goes wrong with your attorney. Firms could be a solo practitioner of just one attorney. They could be 2, 3, 4. These firms can go up to like thousands of attorneys. So when you're hiring an attorney, consider what would happen if for some reason the attorney needs to step out of the office, take an emergency leave, if he's going on vacation. You want to see if there's anyone else that you could speak to. Would your case just be put on the back burner, or would it be picked up by another attorney? This isn't to say that firms with more attorneys can be a better fit for you, because solo practitioners, if you're one attorney, you are a big client to that one and they can really prioritize your means. It's just something to consider of what would happen in the event of a what if. You don't want your circumstances to be put on a back burner, and then you're calling a month from now and you have no idea what the status of your legal work is, and you're put in a tough situation. So it's definitely an important thing to consider, and just feel out your gut feeling about it. And in a meeting, once you speak to this attorney, once you have, you're going through these qualities and you're finding them, some questions to ask in the interview process it could be pretty simple, just to help you gain an idea of whether this attorney is a good fit for you and whether they can represent you competently. The first question would be, have you handled cases like this before? You want to make sure your attorney is experienced in whatever situation you're putting out to them, whether it's unique or it could be just a simple, basically like an entity formation. You want to make sure they've done it before. If they do it wrong and if they don't have experience in it, that you don't want to deal with that at the end of things and find out the hard way. Ask them to see what options they suggest for your position. Ask them if there's, if you're dealing with an employee issue, they can suggest you options that are the best fit for your company. Some routes to go, some things to consider, and some things to avoid. Ask them what information that they need to effectively represent you. In a consultation, in the beginning of things, if they give you an idea of the information they need, you can start preparing them and emailing them to you without them having to ask you later again while they're billing you. So you can either get it done with in the beginning and make sure that when the attorney starts working, they're doing work rather than asking you for documents and charging for it. So it could really help make this efficient and effective and productive process, and cut out some costs from your end. And then ask them what problems they foresee, if any. Some complex issues can have some unforeseeable circumstances, but that's not to say that they can't foresee anything. So it could help you dodge a few curveballs and slightly see around the corner and give you a little bit of comfort on where this is going, both substantively and financially. At the end of the day, you're the one paying for it. So you want to keep considering if a big issue is likely to happen, plan and budget and figure out some alternatives accordingly. Next is, what are the next steps in retaining you? Oftentimes we'll meet and and we'll get some information, and then life will happen and you haven't reached out to the attorney, and you only remember that it's time to reach back out to the professional when you need that professional because you got a letter in the mail that isn't very nice to your business, and you don't want to catch that. So in that consultation, ask about what the next steps are in retaining that person. It'll get the process effectively and efficiently going, and it'll make sure that if you're hiring this attorney right now, they have the capacity to take you on. Ask them approximately how long it'll take to close your case. Complex issues can be unforeseeable. You wouldn't likely be able to get a good idea of how long it'll take, but preventative issues such as entity formation, document formation, handbook formation might be, and they can have a ballpark range and fee that they charge. So it could also help you figure out the cost of things and a range of how much you're going to be spending and whether you can afford to hire the attorney to get the actual job done rather than have to stop halfway through and be unable to continue the rest. Lastly, it's how do you bill? Attorneys' cost structures vary, and it's very important to know exactly how this attorney is going to be charging you. And it also helps you understand how much money you have to budget for and whether you can afford this or not. So I'm going to pass the presentation to Nicole, and she will tell you about the fee structures, how to read a bill, and the power that you have in in an attorney-client relationship, and also some other things to consider. So take it away, Nicole.
Right. Excellent. Thank you, Adrina. So fee structures, there's a number of different structures that lawyers use for their fees. The most common ones are by the job, by the hour, and contingent fees. So a flat fee is what we usually call a by the job fee. This is where you have a discrete matter that you need the lawyer to handle. Business formation, drafting an employee handbook. These are the examples we've heard here. There's a start and an end to it, and it's typically not going to be super complicated outside of those boundaries. So a lawyer might give you a flat fee rate for that job to cover it start to end. A contingency fee is something you might have heard of. It's more typical in lawsuits, and not just a lawsuit, but a lawsuit that you start. So if you need a lawyer to help you recover money that's owed to you or damages for something someone did to you, they might be willing to take it on contingency fee, meaning they don't get paid unless you get paid. This can often be a big chunk of what you get paid though. 1/3 is not unusual. And it can also vary depending on where the case is and where it settles. And it's always going to be spelled out in a written agreement. So for example, if you settle a lawsuit early on before you file suit, before they spent a lot of time on it, they may not get a big lawyer's fee. But if it's right before you go to trial, they're probably going to have you sign something that says they get more if it's right before trial. An hourly rate is probably what most people think of when you think of a lawyer's bill. Usually comes along with a retainer, a flat amount that you give them up front that they then put in a trust account and they take out of the trust account as they do work for you. This is a way to secure the lawyer's services for something. Hourly rates vary. It depends on the position of the person in the firm and the person that you're working with, and also the geographic area that you're in. Burlington rates are higher than they are in Brookfield, for example. Sometimes you can get a lawyer to take your matter on a pro bono basis, which means for free. It never hurts to ask. Lawyers have an aspiration to accrue up to 50 hours of pro bono hours in the state of Vermont. You might find a lawyer who wants to help out, but don't expect the answer to be yes. They sometimes need to be able to recover something for their services. So there are also low bono projects or low bono, like the modest means panel that Adrina mentioned. There are pro bono projects throughout the state. Some of these were mentioned earlier: Legal Aid, the South Royalton Legal Clinic, the Vermont Law School Entrepreneurship Legal Lab. We do free services, and some other clinics. There's also clinics for things like discrete parts of a dispute, like the land use clinic, the environmental division clinic, which is one that I do, or there's one that's held for landlord tenant evictions, for example. The Vermont Bar Association is the best resource to figure out where these opportunities are. You can always ask for a discount from a lawyer. You may not always get it, but you can ask for it. A reduced rate is also sometimes called a low bono rate. You can ask if they can help you out for a smaller amount, if they can discount the time that they spent on your matter, If you pay it in a large chunk, can they discount the associate's rate based on your budget? These are all valid questions to ask when you're talking about a fee. There's something called unbundled services, which refers to a trend lately that the state is encouraging, where a lawyer helps you for a small piece of your matter and only that part. Typically, it means that you don't pay as much for the lawyer's services. They unbundle their services, represent you for a very limited purpose, and then they charge you less for that. Whatever the case, you should always expect to get a retainer letter to start your relationship. This is going to set out an explanation of what you're paying for, and what happens if you don't pay. Your lawyer should also take the time to explain all of this. So if they don't explain it, you need to ask. And of course, if none of the above works for you, you can negotiate. And I'm going to go through a couple suggestions for how to negotiate with a lawyer in a little bit. How do you know what you're getting billed for? What do you do with a lawyer's bill? Well, the first answer is read it. If you're paying the bill without reading it, in my opinion, you're doing it wrong. Your lawyer typically includes information they want you to have in the bill. You should take the time to read it, read through it, learn what you're paying for and why. Be prepared for their time, if it's an hourly rate, to be broken down in 6-minute increments. This is how lawyers bill, 0.1 hours, a tenth of an hour. I can speak for most lawyers out there and say this is an absolute bane of our existence. We hate this uniformly, but it's also how we feed our families. It's typical to round up to the nearest tenth of an hour. So that means a 2-minute email that the lawyer sends to you becomes a 6-minute email by default. And once you hit 6 minutes, depending on their billing software, it might actually go up to 0.2 hours. So you get billed if it's 6 minutes and 3 seconds. Some lawyers bill by the half hour, some bill by the quarter hour. So for example, for a tenth of an hour, $75 an hour rate, which is pretty typical for what we call low bono, that's $7.50 every 6 minutes. For a $350 an hour rate, which is pretty typical, for example, for a partner in a firm in Burlington, that's $35 every 6 minutes. It adds up. The description of the work is important. You should be reading this. Lawyers will typically describe the work that they've done. Some use more detail, some use less. Some might just include a bulk work description, especially if you're paying for something by the job. Some get very specific. Read the description. It should tell you what they did, and it will hopefully show some progress on your matter. An absence of progress in the bill might be a reason for you to check in with your lawyer. There's also a difference between associate and partner billing. Associates bill at lower rates than the partners or the shareholders. Associates might also be on a learning curve because they're fresh out of law school. It's typical for associates who are on that learning curve to spend more time than a partner would on a matter. And it's also typical for that associate's time to be no charged or discounted to reflect that reality. Watch for it in your bill. You can typically trust associates to do a good job. They've gone through law school, or they've studied for the bar, they've read the bar, they've passed the bar. You can also consider asking that somebody else do the work. You can ask for a partner to do the work or an associate to do the work. You can also watch for an associate's learning curve to be billed to you. You can always dispute that. I want to warn you that some of the bigger firms, if you hire them, sometimes have a partner review. And this means a partner will spend a half an hour reviewing your file once a month, and they'll charge you for it. It may mean that they pick it up and they look at the file and they set it down. So watch out for that. You can always dispute that as well. It's also possible to see a paralegal billing on a matter, and they bill usually at a rate that's lower than an associate. You can always ask for more details. If there's a time entry and it's super vague, you can ask for more information before you pay for it. If you're not sure who did the work, you can ask for that too. Long story short, don't just pay the bill, ask questions if you're not sure. You do have power in the relationship with your lawyer. You can educate yourself. And the more that you educate yourself, and maybe we'll be able to touch on LLCs at the end of this. That's a good question, Emily. The more that you educate yourself, the less you're going to have to pay for your lawyer to educate you, right? You can take the time, you can Google your questions, just like anything else out there. Please be wary of what's on the internet. It's not always correct. You can also reach out to our program, Vermont Law School Entrepreneurship Legal Lab. We offer free educational consults to a lot of businesses on relevant topics. We're happy to help you. Make sure that you communicate concisely. You pay for communication with your lawyer, so keep it simple. Lengthy emails take time to read. Long phone calls cost money. Texting your lawyer, if they let you text them, is going to cost you something. So keep it simple, and short, because you don't want to pay for too much communication. You can set expectations with your lawyer up front. If you only have a certain budget, then set expectations for what your budget is. What are you going to be able to pay for? What is the cap on the time that they spend? Do you want them to spend no more than 2 hours and not bill you beyond that? Is it open-ended? Are you going to pay for research? Are you going to pay for them to revise a document? Are you going to pay for a partner to review it, or will you only pay for the associate? What is your budget going to cover? How much time is going to be spent on it? How much time is invested in each part? And then consider markers for progress too, before you renew the retainer or decide to go another direction. You can set out expectations for communication. How often are you going to communicate? In what format? Who will you communicate with? The partner, the associate, the secretary? How often are you going to check in and get an update? Respond timely. This is really important. The more time you take to respond to a lawyer asking for something from you, the more likely your lawyer has moved on to their next matter. And the more time it takes them to catch back up when they come back to yours. And you pay for that. Responding quickly to information requests is really important. Adrene hit on that earlier. It works to your benefit to respond quickly, so stay on it. And then finally, you do have the ability to terminate the relationship with your lawyer. If you're not satisfied with them, you can fire them. And it is, believe it or not, is pretty common for people in law firms to say, oh, I got fired today by my client. You can request an unearned portion of your retainer be returned to you. If you're in litigation, you probably will need to get a judge's approval. But just like any other relationship, you can control whether you're in it. A couple of other things to consider before we turn it over for questions. I'm not sure if anybody's aware of this, but there's such a thing called IOLTA. It's very common for folks to think that the lawyer is putting their retainer money into a trust account and then making money off of that retainer. What happens is a lawyer has to have a special trust account, an interest on lawyer trust account. Money from their clients' retainers goes into the trust account. There is an interest rate, and whatever interest accrues on that amount goes to a special fund that pays for legal services for low-income Vermonters. So if you're under the impression your lawyer is making money off of your money, think again, your neighbor might actually be benefiting from legal services that are paid with interest on your money. That's called an IOLTA. You are able to negotiate. I know we've said this a couple of times, but I can't emphasize it enough. You can negotiate with your lawyer. You can negotiate retainers. You can negotiate the fees. You have power over this. You don't have to accept a retainer or a fee quote. You can bargain. You can ask for a second opinion even. There's certain areas of practice in which there's not a lot of lawyers doing that work, but those are pretty rare. A lot of lawyers have a pretty broad base of ability to meet your legal needs. Most often you're going to find someone else who can help you if you don't feel like the first lawyer you go to is willing to negotiate. If you do negotiate, you'll probably find that lawyers will be flexible to a certain extent, especially if you take the time to educate yourself. If you appreciate their time, you limit the amount of time that you take up that they have to bill for. And then this last topic, I love this, bartering. You might not be aware of this. You can barter with your lawyer. Do you have food that you make? My favorite one is maple syrup. You can barter maple syrup for legal fees. And I got to tell you, like, my favorite moment as an attorney was getting cheese or food or some sort of product from my clients in exchange for legal fees. It's a great part of practicing in Vermont, but particularly useful for business clients who have something of value to offer. Do you do sugaring in the spring? Do you trade maple syrup? Are you a farmer? Can you give your lawyer a CSA in exchange for a portion of the bill? I've seen a lot of these things. I've seen ski passes being exchanged for lawyer bills too. Childcare, exactly. There you go. If you provide a useful service, see if they'll trade you for 6 months of service for their fees or a retainer. It's always okay to barter and to negotiate. Get creative is the rule there. And then the last lesson, curveballs happen, especially in litigation. If there's a lawsuit happening, just be prepared for things to come up that you don't expect. The best thing you can do, as Adrene very, very well put earlier on, is to use an ounce of prevention rather than a pound of cure. So that is how to hire and work with a lawyer. Does anybody have any questions? We had one about setting up a business as an LLC. Any other questions? Because I might actually have Adrene talk to that one, speak to that one, since you've been doing that presentation lately.
Yeah, just to cover that.
Can I just interrupt for a second? Maybe we could take the PowerPoint down, this was fantastic.
Great.
and then go back on the screen and see and answer this. There we go. Great.
we go.
Thank you. Really, I gotta say, this was fabulous. Thank you. But go ahead and answer the questions.
Thank you. No, this is awesome. To answer your question for an LLC, what an LLC essentially is that it's essentially if you are a general partnership with someone, and if you are in partnership with someone running a business, it's no different than that, except it limits your liability. So all that it is a legal wrapper around that partnership that says that me and the company are separate. If something happens with the company, I can't get touched. I won't get touched. There's very limited reasons why they can pierce that shield for liability and get to you, but it's not often and it's very rare. A way to file for an LLC, how to become an LLC is there's a few steps with filing forms with the state registrar's office. I think for Vermont, it's the
Vermont Secretary of State.
It's a Secretary of State website. You file it with that. There will be articles of incorporation. Just a few. They're almost like standard things that might seem really confusing and very big wordy, and it becomes a little stressful. But they're very clear to the point, and a way to get around that. And honestly, if you're not looking for anything crazy in incorporation, anything really customized, you can go on LegalZoom and file this for about like $60-$70. It's $70 compared to potentially something, absolutely anything happening, and to dig into the pockets of the business, they go at your assets. It's just, if there's risk involved in any way, especially for childcare, if a kid gets injured in your home or where you're caring for them and you don't have some proper things in place for like a waiver, that can get pierced, and now you're getting sued personally for issues that accidentally happened in your business. So you can file that with the Secretary of State or go straight to LegalZoom, select Vermont, and it'll immediately give you all the requirements of just the information they're going to take from you, and they put the paperwork together on their side of things and file it with the state. So it could be as simple as that.
There is also, I want to mention, there is a free resource on the Secretary of State website. There is like an LLC wizard type thing. So you might want to look at that as well. And then I also want to mention there is another part of, so I just wanted to ask, so Adrene, can we have a single member LLC?
I don't believe that you can have a single member LLC, but let me look into it.
You can actually. So the answer is yes, you can have a single member LLC. And you get the same liability protection. So there you can be one person and be an LLC. You can be in a general partnership that becomes an LLC and puts that shield up for you. Recommendation, and just to explain a little bit, is if you're a single member LLC, you may not need to have an operating agreement necessarily. You have to file the articles of incorporation with the state or the articles of organization. But if you are in a partnership, it is often very useful to have an operating agreement if you're forming an LLC that lays out how are things going to happen, how's the business going to run, who's going to make what decisions, and then one of the most important things from my perspective, what happens if things go wrong, if you disagree with your partner. So that can be very useful to have. Again, there's some free resources. You can DIY some of this stuff, but it helps enormously. And I got to tell you, setting up an LLC is a very common thing for a general practice lawyer to be able to do. It's not too hard, and they've already got the forms. You could go on LegalZoom, like Adrene said, or you could do the DIY option with the Secretary of State, or you could pay a lawyer not much more to see if they can spot any other concerns that you might have for your business to address. So there's a couple of different options. Good question, though.
And Emily, and those of you on too, if you're Emily, I'm not sure where I should know where your business is located, but that's something too. If any of you have questions that you want to, further questions, you can always send me a note and I can put you in touch with one of our business advisors, or I might be able to answer it for you too. So. Yeah.
Thank you. I did have one question regarding the LLC. Is there any drawback to doing the LLC? Is there any, I mean, I hear all the advantages. Are there any disadvantages of having it? It sounds to me like there's just like no reason not to do it.
What do you think, Adrene?
If you have any risk, even in your mind, that you think your like company could face, I say LLC. I mean, every time I hear LLC, I'm like, there is no reason not to. It's like, I feel like people stray away from it because it sounds so serious, but it is. So drawbacks are that you're not personally selling your house if something goes wrong. Everything is limited to what's in your business. So if anything happens, the assets of your business are all that's at play there. So I wouldn't see why not.
I'll say one thing, and I'm sure that the two lawyers here can back me up on this. When you're, if you set yourself up as an LLC, first of all, you do have to get an EIN number, a federal ID number, whichever you should be using anyway, versus your social security number. And then you also need a checking account in the business name in order. And you need to make sure that all of your correspondence and you don't need it in huge letters, but your business cards and your letterhead or whatever has on the name, like Emily Pryor, Child Care, LLC. Otherwise, there's certain things you need to always show that otherwise what you're doing is you're still to the public, you're really looking like you're still a sole proprietor. So you need to just be careful on a few things like that. And it only costs $125 to register, and I think it's $35 a year for as an additional filing fee each year or so.
I also want to mention, those are really great points. Thank you, Laurel. I want to mention too, that if there's any sort of assets that you're not sure what to do about, there is a possibility of setting up a contract or a lease between the business and the individual. So for example, if you happen to be using your home for your business, you might consider leasing a portion of that to the business so that there's at least a line between the business and the asset. And that way you can protect certain portions of what you have, or you just leave it in your name and the business uses the facilities. But there are ways to do it. Again, lawyers are really helpful for figuring these things out and the best way to protect your assets in the event that something goes wrong. And I think Ms. Pryor, you had a question.
Yes, I did. I was wondering about what Laurel just mentioned about the checking account for your business. I've never had a separate one. So how would that look, or do we even know how that looks for family childcare? How you set up a business account? I don't know if this is the right place to ask, but it I've never done it because I didn't think it was just such a hassle of transferring money back and forth. So I was just curious.
My advice would be to set up the LLC. As Laurel said, get the EIN, and then you can open the bank account.
And you know what? I'm gonna go. I think one of the cool things about taking this program is that really starting to think that you are a business. You're in business. You're women business owners, and so this is part of being in business. And so now what you're doing is you keep your personal funds and your business funds separate, so you can, there are times obviously you're going to have to you might have to draw down on your personal funds to cover some stuff, but if you keep those things, like an entry that's keeping that clear, then you can see what your equity is and so forth in the childcare business. So yeah, this is a really good process in order to keep things clean. So
yep. Any other questions? Carolyn says, I was told that it just makes it harder for them to jump through the hoops. They still can attach to your assets. Therefore, some may not sue because it's harder. That's true. It makes it harder for them because there's that shield. There's the corporate veil, if you want to call it there. It does make it harder. They can attach under certain circumstances. That's why if you figure out how to separate your assets and your business, that's where it comes into help. They may not sue because they might look at the LLC and see that you don't have any assets in the LLC. They're all in your name and they may not be able to get through that wall. So that may, lawyers will recommend that their clients go after the deep pockets. And if there's no deep pockets, they may not go after you. So there you go. Lisa says keeping financial accounts and records separate and up to date also makes it easier at tax time. Yes. And here I'm just going to drop like the most basic business advice you can get. You should have an accountant on your side. That's one of your trusted advisors. you need to talk to an accountant, especially if you consider any of the different business structures you might go into. An LLC really serves almost everybody, but if you consider going into a different structure or a different formation, it's always a good idea to talk to an accountant to see if there's any tax benefits to that. Great. Oh, and what I'm going to do is put in the chat www.vermontlaw.edu/CNPP. This is the website for our Community Navigator pilot project. This is what we're doing in partnership with the Small Business Development Center. We have a grant through the federal government where we are helping small businesses that are owned by the diverse community. So including women-owned businesses, BIPOC-owned businesses, LGBTQ-owned businesses, rural businesses, veteran-owned. We have the ability to not only provide a free educational consult to these businesses, but also to potentially refer them on for 5 to 10 hours of free legal services if you qualify. So that website will take you to a description of the program for Vermont Law School, and it has a little button off to the side that says it invites you to submit an inquiry. That inquiry goes directly to me and Jeanette Ikes, who is helping me manage the program, and we can set you up with an educational consult and see if we can help you out. Geraldine says, does the home become available to a suit because we work out of it? Would that be considered a deep pocket? There again, in general, folks who have figured out how to separate their assets from the business, there might be a lease involved between the home and the business, but generally they're not going to be able to come after the person's home for the building that is leased. Just like, for example, say if you're a bakery leasing a building and something happened at the bakery, suing the business, the bakery, doesn't necessarily mean they can go after the building owner. So it's a similar concept.
And if I can add to that, part of keeping those assets separate is your banking. If your personal fund, if this is you and your personal fund is here and this is the business and your personal funds are going there, it could mean that it could be argued that although you're an LLC, you're not operating as one, you're not operating separately, and you're just pulling out from the business's funds like it's nothing, even though it's your personal funds and it's absolutely okay. But if you're an LLC, it could raise the argument that you're commingling funds and you're not running in an LLC, so that corporate veil can be pierced, so that LLC legal protection can be lifted, because they say you're filed as one, sure, but you're not running it like one, so they can take it off and then problems.
Yeah. There you go. So there's the answer to your question, Geraldine, right? So if you maintain separate bank accounts and you maintain separate buckets, basically, then it's far less likely that they're going to look at your home and see that's part of the deep pocket. Great question.
Mm.
If I
It's
could
so
just
fun.
add, while people think about other questions that they might have, I want to remind folks that sharedservicesvermont.org has all kinds of templates around job descriptions and program handbooks, none of which replace the need to have legal review of things, but they're templates developed by trusted partners, national partners who use best practices. So that's a great place to start when you're developing handbooks, when you're developing job descriptions. It's a great place to start. And all the regulated childcare programs in Vermont have access to sharedservicesvermont.org at no cost.
Great. What a good resource. Anything else, folks?
Well, I can't thank you enough. I'm glad we had some folks on, and those of you
Yeah.
that are on, I'm sure you learned quite a lot. I mean, I actually learned quite a lot. So that's I always learn something new whenever I hear a speaker. But you know, by now I should kind of know some of the things that you talked about, but I learned a whole lot more. And I think there's some areas. I know Tammy was all excited. She said, "Gosh, can I share some of this with my students?" And I said, "Yes, you can, of course." You know,
There you
so
go.
because I think it's really important that we have more, especially, you know, young people, and of course that our childcare providers that you're on now, but people, you know, just have an opportunity to hear what's your options are, you know, and sometimes we don't, sometimes we're afraid to ask questions
Yeah.
because it's like, oh, we don't even know the question to ask. We're not even
Right.
sure where to start. So I think this really helped to answer some things. And I know that you're available if you have, those of you that are on have some other questions, you can always send a note to me and I can help sort of, facilitate getting it off to either one of our advisors or to maybe setting the time with someone from the law school. So how's that?
Sounds
This
great.
was great. This was amazing. Thank you so much. We so
Yes.
appreciate this partnership.
You are welcome, and we are so appreciative of it too. We absolutely love the work that we do at the SBDC. It's fantastic, and I'm
Great.
just getting into this work, and I can't tell you how fun it is.
Cool. All
Thank
right.
you.
Well, thank you. So we'll stay on for a few more minutes if those of you that are on, participants and so forth, if you have other things you want to talk to Tammy or Lisa about. Otherwise, thank you, Nicole and Adrina. So
Sounds good. Take care, folks.
Thank
we'll
you.
have a good weekend after tomorrow.
yes.
Hey,
Yes.
everyone. Have a nice weekend.